So, if we could have the objection heard outside the presence of the jury.
Go ahead, Mr. Gravely.
Yeah, what?
What did you say?
I do want to do it outside the presence of the jury. I apologize. This thread is something that we've litigated prior.
Generally, well, folks.
Apologize.
Judge, if I may.
Quiet, please. I'm going to ask you to step just into the library. If somebody needs to go upstairs, you're welcome to do so, but come right back down. But go into the library, and I don't think this will take long, and make yourselves comfortable there, please. Don't talk about the case, please. Gravely? I hadn't pressed the button, that's why.
My objection is that the defense line of argument that's just been stated regarding Sadie Beecham is a violation of State v. Denny. To be able to name a party and indicate that there are factual circumstances that are consistent with them being guilty of procuring this homicide in the alternative is exactly what Denny was designed to prevent. The court is aware that Denny asks that the defense file a written motion giving all parties notice so that the parties do not, in mid-trial, have alternative actual named parties be described, as well as factual circumstances which are designed to cause the jury to suspect that person is an alternative individual. This is exactly what Denny was designed to prevent. And now the name Sadie Beecham has been associated with this jury with being involved in planning a homicide of this individual, and that's in direct violation. There is no doubt that the defense is on notice as to what Denny is or its expectations. We litigated a Denny motion just last week where they laid out a direct foundation. These are, again, the quoting to the jury are text messages. These are not new pieces of information. And frankly, as I indicated in the prior Denny motion, the court has an obligation as a steward of this information to be sure that all parties are dealt with fairly here. We are required to be able to be provided notice if individuals are out there in that situation and be able to defend those individuals, and the court is required to rule on this beforehand. So I believe this to be an improper argument. I don't think it can be cured at this point, and so I ask the court to consider what our remedies are, but I believe that this is a clear Denny violation and that this is a mistrial.
If I may be heard, Judge. Thank you. In my opening statement before I started going into this sequence, I talked about how law enforcement did not follow up or look into anything as far as possible other suspects or leads. I'm not offering this, and first of all, I'm just talking about the evidence that's going to come in, right? At this point, this is what the opening statement's for. This is a message string between Miss Beecham and another witness. This will come in. And it's not to offer it, Judge. It's not to offer it to say it was her. It's to offer it to show that law enforcement did not investigate her, did not investigate anyone else. That's not a Denny motion. I'm not pointing the finger. I'm not saying Miss Beecham did it. I'm saying they could have followed up on this, they should have followed up on this, and they didn't. It's very different.
First of all, you're telling me it's not coming in. And if it's not coming in, then you're not supposed to talk about it.
No, I said it is coming in, that this will come in through witnesses.
Say it wasn't going to come in.
No, sorry if
I heard you wrong.
Okay.
Did you want to respond, Mr. Gravely?
Yeah, you can talk about whatever purpose you want. The argument made to the jury is other people should have been looked at. I mean, you couldn't be more clear in your argument. The argument was other people did this crime. My client did not, other people did. Here's example one. And she's now laid out specific electronic evidence that she wants the jury to be presented. So not only is she making an accusation, the substance of this accusation is that Sadie Beecham and a friend of hers have conspired to find a third party who will kill this person. That's the allegation that's been just made. And she's indicating that's what the text would lead a reasonable person to believe. There's been no notice of that specific allegation. The jury has now heard it. It's been shared with the jury. There's a whole body of case law in Wisconsin that does not allow a private citizen to be accused. And for a person to say, well, that's not for the purpose of accusing another human being of murder, that's what she's done. That's the argument that's been made. It doesn't matter if that is not if that's not the sole purpose you have. Your objective here is to tell the jury, hey, there's reasonable doubt. Sadie Beecham did this. Look at this electronic message. That's why you argue that. There's no other reasonable argument as to why this has been shared with the jury. And why weren't we given notice of this? Why wasn't, when a Denny motion was filed with all the details, and I complimented the defense just a week ago when they provided their factual circumstances so the court could litigate that with the state, because I believe that's the entire proper procedure. I'm on record as having complimented them for supplementing and providing a factual basis for the court to make a fair ruling. And we are in complete absence of that in this situation. This can't be remedied. Sadie Beecham has been accused of murder when Denny exists as litigation in this state.
If I may respond.
Go ahead.
Thank you, Judge. I have not accused anyone of anything. I think it's been very clear that the defense is saying that none of this evidence exists, and law enforcement, instead of doing their jobs to investigate, just went with a single individual, that they had tunnel vision. An extremely proper defense, and this does not fall under Denny, is to say what the law enforcement didn't do. I'm not here to purport that this is what happened, nor have I said that. During trial, it'll be, this message was sent. Hey, detective, were you aware of this? Did you look into it? Do you think it's a little bizarre? Yeah. And leave it at that. Nowhere have I just said right now that I intend on pinning this all on Ms. Beecham, nor have I think that has been the theme of my opening statement.
But if you don't have greater information than that, and why is it relevant? I mean, what difference would it make whether the police followed through on it or not, unless there's reason to believe that that was the person who was responsible for the disappearance of the decedent? It's irrelevant, and I mean, I'm hoping they didn't investigate me too, or Mr. Gravely, or Ms. Grzarek. They'd have to have a reason to do that. And if there isn't abundant reason to suspect that Ms. Beecham was involved, then I think Mr. Gravely is quite right. This is just a camouflaged Denny effort.
The defense would respectfully disagree with that, Your Honor. By sustaining the state's objection, the court would ultimately be holding that the defense cannot go into how law enforcement didn't do their job, which in a case where there's no body, no evidence of human remains.
Why didn't you file a motion?
It's not a Denny motion. I'm not offering this to point the finger at someone to say this person did the crime.
I have an alternative actor theory.
It's not an alternative actor theory, and if I could maybe give a preview to what was going to come next, is the 20 other things that law enforcement didn't follow up on. It's more targeted, if I may finish, it's more targeted to what law enforcement did or did not do, opposed to what some third party did or did not do. That is what this is going towards, and the defense would maintain that that is extremely relevant. It does not fall under the curtails of Denny, and that we are permitted to go into that in opening argument and during the pendency of this trial.
Okay, I want to be heard on the precise thing that was said by the defense, because this is a disingenuous argument to say, my argument is just a police officer. Here's the text message. Isn't this weird? That's what she just told you. Here's what she represented to the jury. She said that she read the text message and said that this mysterious third party will take care of this, but you won't know the details, and we'll know in a week, right? And then she said, she commented to the jury, and a week is when Sadie Beecham goes and discovers this bloody scene. So she ties it in. She says, guess what, jury? At the end of the week, it's Sadie Beecham who, in response to this message, has now made this discovery. This is implicating Sadie Beecham directly in a homicide. That's the only reason you make that argument. She didn't remark, and I didn't object when she first began to speak. What she told the jury was that this is bolstered by Sadie Beecham being the person who discovers this scene a week later, which is in accordance with the detail with the text. This should not be investigated by the state on the fly. This is just not Denny does not allow a scenario where a fellow human being can be accused of a homicide and the state is expected to figure out on the fly what this information leads to. The jury has every reasonable expectation right now that Sadie Beecham could be the killer based on what's been said. That should never, ever be said in a courtroom until Denny is litigated, ever. I mean, this is a line that it's not even a close line that's being crossed here. And we cannot remedy this, Judge. It cannot be remedied for this jury.
What I was going to say before the objection came was that even just, okay, so it's still, again, not being offered to point the finger at her. And I'm not sure.
Frankly, your Denny motion that I denied with respect to Mr. Campbell, I might have granted the one on this one because there is not more body to it. So I think Mr. Gravely correctly is concerned that this is just, as I said, a camouflaged Denny motion or effort.
I disagree. The defense disagrees. This is law enforcement. So we can't go into how law enforcement investigated this crime then. Would ultimately be the court's holding. Because there's
that's not the court's holding.
So why didn't you investigate the person who just happened to find all of this? So is that pointing the finger?
That's not the issue before me. This isn't midway through the trial that you didn't ask some probing questions of the detective if he testifies. And ask, well, did you look at this? Did you look at that? To try to show a sloppy investigation, if you think it was. This is in your opening statement and planting a seed and it's all right to plant seeds, that's why we have opening statements, but this particular one has a special body of law handed down to us from the Supreme Court of the United States, and as I say, you correctly brought the Denny motion on Mr. Campbell's issue, but I think this is, well, it's in the same category.
If I can further be heard.
Yeah.
So what is the difference then between saying law enforcement, because I do anticipate talking to Carrera and other detectives about these messages, about whether they looked into any other possible individuals, which is not a Denny motion. And so what's the difference between me saying to a jury in an opening statement, which is what I believe the evidence that's going to come in is going to come in, that this message is going to come in and law enforcement did not follow up on that?
I'm not going to pre-screen what you might or might not ask.
But I'm saying...
you're capable of making your own decision about whether you want to ask the question and what the risk would be. But this is a concrete issue that is before me now, and I think it's correctly analyzed by the state, and what I'm struggling with is what to do about it.
Well, Judge, frankly, a Denny requires notice. So this jury is tainted. We need the court to provide us an opportunity for, if this is an argument they wish to make with an individual identified, they need to notice us, provide us what the factual basis is they're going to allege, and allow us to counter that. This is what happened with the Campbell situation, right? We have the police look at their information, do an investigation that would allow the court to be provided both sides of what that information would entail. And then the court is able to make an educated gatekeeper determination. That wasn't done here. Counsel would be prohibited from arguing an opening or closing without Denny guidance, without the court gatekeeping under Denny any of this information. So under whatever shield they want to use, whatever they want to label it, it still can't be argued in opening or closing as something that is alleged in this case unless the court gives them permission. This is a mistrial. You cannot take away a suspect from a jury. You can't do it. And they should provide the proper notice, as Denny requires, as they did on the prior attempt, and we should have a chance to litigate that before this court. And it shouldn't be a day's notice. It should be sufficient notice for the state to do a real investigation.
Naturally, the defense is maintaining that this isn't a Denny issue. As far as notice, if this is concerned that this text message is coming out of nowhere, these are records that were provided by the state. These are records that the detectives in this matter have went through months ago. They've seen this text message, and if they haven't, that's on them. It's not my fault to make sure they've looked at every piece of paper in the discovery that they provided to me. I found it. I intend to use it to show that law enforcement honed in on my client and didn't investigate anything else. That's not a Denny issue. So as far as notice, the state's had this information. I'm not using it to point the finger at Sadie. I'm using it to point the finger at the fact that law enforcement did not do an effective job investigating and instead painted my client in a certain way. And as the court's aware, this is a bodiless homicide. There's no human remains. There's nothing. And the investigation of law enforcement should be the focus of a defense here.
I'm not sure that it makes any difference whether there's a body or not in terms of this particular issue. But now, before we break, so that I can look at the authorities on this again, ordinarily I have an individual colloquy with the defendant when there's a motion for mistrial about jeopardy. And actually the first case here was dismissed without finding on jeopardy. I didn't have, ended up as a motion to dismiss without prejudice. And I'm not obliged to go through a waiver colloquy with you, but you need to understand that if you're wrong about this, and I agree with you and am wrong about it, you're done.
Yeah, I'm aware that the appellate court makes its own decision on these matters. I'm aware of that. I'm aware that the body of law indicates that if the court makes discretionary decisions, and if the Court of Appeals agrees with the court's exercise of discretion that the defense has engaged in a form of misconduct in this case, that jeopardy does not attach. So, I understand that the Court of Appeals could disagree with the court's exercise of discretion, but I believe that is the litigation that would take place.
Well, you refer to it as an act of misconduct by the defense. It could be an act of mistake by the defense.
Absolutely. Right.
Yeah.
When I say misconduct, I mean it in the broadest sense. Yeah.
Okay.
But clearly it was a deliberate argument, and it was a deliberate decision to not file a Denny motion. So this is not an accident. It may be a disagreement about the law, but this is not accidental conduct.
Well, I don't want to get into that, other than to say, I made a comment
Yep.
that I thought that her argument on this issue would have probably been stronger than I didn't say probably, I said was stronger than the one with the other, I don't know, I'm stumbling.
Campbell. Right.
But she could have also, in good faith, thought the other way, and she brought the one on Campbell, and I denied that. Maybe she felt that was the stronger. That's not deliberate. That's a deliberate choice for her to bring that particular motion, but it doesn't mean she thought that she was bringing the weaker of the two. That doesn't make any sense.
No, she has an obligation to bring a Denny as to each one.
I agree.
Yeah, it's not like an appellate.
But you're saying it was
Also, if I may, I'm
Please.
here and can make the record myself of why I did
You
something.
know what? She's a wonderful, experienced, fantastic reporter, and she's trained. If more than one person is talking at the same time, take the judge. And I don't doubt she could probably take heated discussions, 2 or 3 lawyers at one time. But I don't want to rely on that. You're all talking. And when I start talking, not because I'm so bright or so capable, but just because you're talking to the air. It won't get into the record, or you can't count on it being in the record. So I'm talking. So, and I've forgotten what I wanted to say. Yeah, you know, I don't want to get into purposeful. Well, it was purposeful, but whether it was a willful matter is willful in the sense of trying to avoid application of the rule. I'm not in that situation. I don't have to be.
Right.
But it needs to be understood, and you can say for the Court of Appeals, if there is an appeal out of this issue, your thoughts on the subject of whether her conduct was improper or careless or purposeful in a negative sense. So I'm not going to even touch that right now. I do want to look at the exact statement again, and I'll take another look at Denny and the prior Supreme Court decision, and I'll ask the jury to return at 1:30. And, well, actually, I asked them to return at 1:45, and we'll talk about legal issues when we get back here at 1:30. Any question?
No.
No question. A request, though, if the court could review the statements that I had made prior to my statements about Sadie Beecham as well, because I think that provides the court context as to why those statements were made.
How far back do you want?
To the point that I talked about how law enforcement didn't look into things that should have been followed up on.
I don't think that was a great stretch of time.
No, it wasn't. It was probably like 2 minutes prior to that statement.
All right. Would you do that, please? Do you have enough time? Thank you.
We're back at 1:30.
1:30.